We're just giving a little more time for people to join us. So we'll start in just a few seconds here. Hello and welcome today. Today's Lunch and Learn is estate planning. I appreciate you all joining us on through Zoom. I did want to let you know that we are recording today's Zoom and it will be uploaded later to our YouTube channel. I encourage all of you to use our chat function. It's that little bubble on the bottom of your screen, and to let everyone know that you're here, your major, your graduation year. So in that function, once you hit the chat bubble, it'll pop up a window to your right. Down there at the bottom, make sure that you've selected to share with everyone so that everyone can see your responses. And then today we have both Leah and Bobby speaking. And if you have questions for either of them, I encourage you to use that Q&A bubble with the two talking bubbles at the bottom to add your questions there. And then at the end of our session, we'll answer some of those questions. I want to introduce to you, most of you already know, Leah Mahoney. She graduated from South Dakota Mines with a geological engineering degree in 1980. She went on to work with Amco Production Company for the following 12 years, where she met her husband, Jim, and together they had 3 children. They wanted to move back to the Rapid City area to raise their kids in the Black Hills. And so when she left the Amco Production Company, she joined our foundation part-time. And as her kids grew, she went on to work for us full-time, and she worked with planning, giving, property management, and other development activities. Leah, she's currently a member of our National Association of Charitable Gift Planners. And currently what Leah does here at the foundation at CARA is she manages our gift annuities, estate gifts, charitable trust, and gift agreements for CARA. So I would like to introduce you to Leah.
Good morning. Hello, everybody. Thank you for joining us this morning. I am so excited to have so many of you joining us today and to introduce our presenter for today, Bobbi Thury. She is an attorney at law at the Legacy Law Firm in Sioux Falls, and we are proud to claim Bobbi as an alum of the School of Mines, and we're grateful that she has agreed to address our topic for today, which will be the nuts and bolts for estate and asset protection planning in the 21st century. Bobbi graduated from Mines in 2003 with an interdisciplinary sciences degree. She continued her education and graduated from the University of South Dakota Beacom School of Business with a master's of business administration, and she graduated from the University of South Dakota School of Law in 2007. Following law school, she clerked for the South Dakota Second Judicial Circuit. She was a partner at Cutler Law Firm before co-founding Legacy Law Firm in 2016 in Sioux Falls. At Legacy Law Firm, she is known for her asset protection planning, whether it's for high net worth clients or for sheltering assets for those running out of money in a nursing home. She is a board certified estate planning law specialist by the National Association of Estate Planners and Counsels, as well as an accredited estate planner. Bobbi is also the only certified elder law attorney in South Dakota certified by the National Elder Law Foundation. She's accredited by the Department of Veteran Affairs, a member of the Academy of Special Needs Planners, and the National Academy of Elder Law Attorneys. Bobbi has gone through the educational process of the Certified Value Growth Advisors and Certified Exit Planner Advisors for family or privately held businesses. Along with her Juris Doctor, she also has a master's in business administration, and she is a member of the State Bar of South Dakota's Business Law Committee. Bobbi is highly regarded in the region in her experience in asset protection planning, complex estate planning, and business planning. She takes a hands-on, holistic approach, and she likes to give very personal service to all of her clients. She's involved with numerous professional organizations as well as local ones, and she's been a great leader and community supporter with service to many organizations in Sioux Falls, including as a board member of the Sioux Falls Chamber of Commerce, Lifescape Foundation, Hope Coalition, Make-A-Wish Foundation, the Sioux Falls Area Community Foundation, and the Sioux Falls Sports Authority. Somehow she's managed to also raise 4 children with her husband, Chad, and they love to spend time together as a family and get outdoors as often as possible and back to Parkston, to Bobbi's home. We are grateful to Bobbi for sharing her time and talents with us today. And with that, I will turn it over to Bobbi.
Thanks, Leah. Hopefully no one's asleep. I'm sorry for that. So anyway, just truly, truly honored to be here as a proud Hard Rocker. It means the world to me. And I'm hoping that I know I'm speaking to an incredibly smart audience. And for those engineers out there, typically we always joke and kid them that we're going to charge them a PETA charge because you ask so many hard questions and want to know the details of everything. So I do hope you guys get something out of this webinar today. It's something that impacts all of us, and so find very important. So I am going to share my screen and start the presentation. So just to kick off, you know, estate planning is one thing, but asset protection planning is another. And you really need to make sure that you're looking at both, because if you do estate planning, but then something happens and you no longer have assets, then you didn't need that estate planning, right? So in today's world, asset protection planning is very important, along with estate planning, to make sure that you're taking care of yourself and taking care of your loved ones. Now, we always kind of start off with taxes. Our philosophy here is that, you know, we definitely want to give Uncle Sam what he's due and owed, but we don't want to give him a tip. So part of that's just being educated on tax laws as it relates to estate planning. So currently in today's world, and so our federal exemption levels are 12.06 million per person. So that means federally estate taxes don't kick in unless you're over that 12.06 million per person. So as a married couple, you know, you have a little over 24 million that you can give. So 99.9% of the population doesn't have to worry about estate taxes anymore, at least on the federal side. Now, states might have their own state estate tax. So we're going to speak generally to the federal law here. But, you know, again, only 0.1% of the population needs to worry about estate taxes. The annual exclusion for the gift exclusion is $16,000 per person. So that means that's the government freebie that we each get, that we can give $16,000 away per person without even needing to report it. Now for the lifetime gift exemption, that too mirrors that 12.06 million. So we're at historic highs for estate taxes and gift tax purposes. That being said, the current tax act is set to sunset. So when they passed the last tax legislation, they did not make permanent the individual taxes. So that means at the end of 2025, it is set to sunset and then revert back to, so it'll jump back down to $5 million indexed for inflation. And what Congress has to do to have this law sunset is nothing. So it's pretty easy for them to do nothing and then anticipate that it might drop back down to $5 million indexed for inflation. And then when you're looking at what does the government look at, right? They really do look at everything. So they'll look at your retirement, your home, your life insurance, if you have life insurance in your name. So they really do look at everything. And you don't get a double dip on your gift exemption and your estate exemption. So they basically reconcile that at time of death. So it's very high now, but we know and anticipate that it's set to move down, and that would have more impact for folks. That being said, it's still pretty darn high, but we're watching because it was proposed to drop down to 3 million. And so if it does have movement downward, this could impact more families. So it's something to keep our eyes on and see what happens. The other thing in taxes that we see is appreciation in land and homes, right? We've definitely seen that real estate values jump up. Now we're seeing some leveling depending on where you're at in the country. But what that could mean for a lot of folks is if you have real estate that's not your primary residence, as a primary residence, you get to have essentially a $250,000 exemption, or $500,000 if you're married and you sell your home as a primary residence. You don't have to pay capital gains tax on that. Now, if you own some other real estate and you sell it, whatever the appreciation is on the basis side, that's what you're going to get hammered with capital gains tax. So for those that live in a community property state, so you'd have to check what state you live, what type of laws you have. You get basically a stepped up basis each time a spouse passes. If you're in a separate state like South Dakota is, then you don't get that if you're married. So then what you can utilize are tools like a special spousal trust, and make sure that you're maximizing your basis planning so that your family at the end of the day gets hit less in capital gains taxes down the road. And for those of you that don't know, South Dakota is actually rated the #1 trust jurisdiction in the country. So that means we have trusts from, New York to California, from Texas on up, people coming here and citing their trusts because we do have such favorable tax and trust laws. So most people, when you're looking at doing estate planning, you're going to be looking at the state that you reside in. But for those that are looking for something more specific with maybe tax planning, asset protection planning, then you get to shop which state works best for you. And South Dakota is #1 really when it comes to that trust laws. So we're pretty proud of that here. Now, the other asset that a lot of people have that's, typically before it was our home, that was a lot of times our biggest asset, but it's really changed so that now our biggest asset that we have is our retirement. So understanding how retirement planning and taxes is important for all of us. In 2020, the Secure Act came into place, and the Secure Act vastly changed the tax planning when it comes to estate planning, how we leave our retirement accounts to others. So there's a number of different changes that occurred with the Secure Act. So for instance, our required minimum distribution age jumped from 70.5 to 72. And there were other changes as well. But the big one and the big takeaway that we want you guys to know about when it comes to estate planning and the Secure Act is that it changed when you inherit an IRA, for instance, anything that was a tax deferred qualified retirement account. It changed if you inherit that as, for instance, a child, it shrinks when you have to take that. So prior to the Secure Act, so prior to 2020, if you inherited a retirement account as a child, then you could turn around and actually continuing to stretch that out over your lifetime. So you're greatly reducing your taxes on that, and you're being able to kind of capitalize on that investment that you have. So it was this amazing tax deferral technique and benefit that we had as American citizens before with that retirement plan that we had in place. Enters the Secure Act. Now with the Secure Act, what it does is it allows you, if you're married, to be able to leave that to a spouse. That spouse is still able to get that tax deferment. They can still stretch it out over their life. Now, there's some other exceptions as well. But if you are going to leave that to your children, that is where the game has changed. So now if you're leaving a retirement account to a child, they now have to withdraw all of it within 10 years. So rather than being able to continue stretching it out over their lifetime and deferring taxes, they now have to take it within 10 years of inheriting that retirement account. Now, there's a couple things. If you have a child, for instance, that has special needs, that's disabled or chronically ill, these tax deferments are able to continue for those individuals. And a lot of times you're going to want to tie it to a supplemental needs trust to make sure that it's taken care of appropriately for those individuals and to allow them to qualify for government benefits, because you don't want them to lose eligibility for the government benefits. Now, as to most individuals, a lot of times there's another exception too, is if you're within 10 years of the person who had the retirement account. For everyone else, though, basically, you got to pay up within 10 years. So if you have an estate plan that was done, prior to the Secure Act 2020, and you have in there that what's called a conduit trust. So if you plan for children who were younger, or maybe you were going to put it into trust for children, you should have your estate plan looked at, because it's likely that those tax requirements would now actually result in a tax consequence, and you're going to end up paying more because those conduit trusts didn't allow distributions to be made. It said it must spread out the taxes and to spread it out over a lifetime. Now the game has changed, and that would result in more taxes. So if you've had your estate done prior to 2020, it's a good thing to get it looked at, just to make sure that you're doing good tax planning. And then as far as what's going on currently, we have the Secure 2.0 right now in Congress. And Secure 2.0 is basically taking the Secure Act that came into effect in 2020, and they're looking at making, I would say, tweaks to it. Now, the Secure Act passed almost unanimously through Congress, which is quite frankly a miracle to see unanimous action, right? So we do believe the Secure 2.0 Act will change. And some of the bigger items on estate planning side is that would be looking at taking the minimum distribution from 72 to basically next year being 73 when you have to take mandatory minimum distributions. And then also over the next 10 years, basically spreading that down to 75 for that minimum distribution age. So that's looking at changing. But the thing on the estate planning side that is not changing is that requirement that you have to, essentially if you inherit retirement accounts, to pull out within that 10-year time frame. So we know that that is the new rules, the new game to play, right? And so you just gotta, have a level playing field, understand how taxes work and what you can do with your estate planning. So part of that now is doing good retirement planning, looking at what's the benefit, what benefits do my children have, or other beneficiaries, and how to maximize that. Because otherwise, if you're looking at your retirement account, there's a big slice of that pie, right? That's going to go back to the IRS. So make sure that you're doing, good retirement planning. There's different techniques that you can use to be able to maximize that. And then the other one with the retirement accounts to definitely always consider is charitable planning. Now, charitable planning is also another tax matter that you don't necessarily need to look at retirement accounts. It's just that you get a bigger bang for your buck out of the retirement accounts. So don't forget it in retirement accounts. With charitable planning, obviously you get that tax deduction when you're leaving it to a 501c3 status for a charity. But I do think, as far as the plan giving, that's also really good opportunities. Some of the primary vehicles that we look at are going to be the charitable remainder trust or a charitable lead trust. With a charitable remainder trust, you are leaving the remainder to the charity. With the charitable lead trust, it's the opposite. You are leaving. So with the charitable remainder trust, you can get the income and benefit right during your life, and then at your death, then it's going to the charity for tax deferment. And then for that lead trust, it's basically the opposite, where you're saying, I am going to give the income to my children for a set term or their lifetime, and then at the end, give it to the charity. Now, one thing to think about with retirement accounts specifically is what we call give it twice strategy. So I'm going to say that once more, and if you're taking notes, it's a good thing to write down. Give it twice strategy, because that's exactly what it does. It gives it twice. So you can set up your retirement accounts and coordinate it with a charitable remainder trust, right? And so with that trust, basically what it's doing is naming the payments will go to beneficiaries for a certain amount of years or their life. And then, so they're getting all of that money during their life. And then the remainder of that, which is basically equal to their initial balance on that retirement account, is then going to charity. Because of that tax planning strategy, you're able to give your retirement account, instead of once, twice. First to children or whoever you want to benefit, and then second to that charity. So it's a fantastic way to work with these new laws really on the retirement side, because otherwise what the government's doing is they're collecting their money faster rather than being able to stretch it out. They want to get it sooner. So definitely think about charitable planning when you're thinking about it, because then the only one that's missing out on the relative side is Uncle Sam. But at the end of the day, who should you be more afraid of losing wealth to? As a side note, if there's any Elaines out there, I'm just going to apologize now. So for the rest of you, you gentlemen out there, I would like you to meet your next wife, Elaine. So just days after your wife passed away, Elaine started bringing you home-cooked meals, and each time she was wearing a little bit skimpier of outfit. Soon she started talking about remodeling that bathroom, specifically that hideous wallpaper that your wife picked out. And she's also trying to get you to live a little bit more, like maybe going on a European spa vacation. So for us that are living with families, right, married, then we do have to plan ahead in case something happens, because there are Elaines out in this world. We look at them as predatory marriages, but we also look at sometimes things happen and it doesn't work out that second time that you get married, right? So it's important to know that you can do estate planning to make sure that your children are being taken care of, and still making sure, right, that Elaine's taken care of as well, but that Elaine doesn't end up with everything or completely being influenced. So a lot of times you might see trust being done, a family trust where that spouse can be taken care of, but we know that the bulk of the assets or a certain amount of assets will be going to the children at the end of the day. So it doesn't all go to new spouse. You can also do prenuptial requirements in order for that surviving spouse to stay on as a beneficiary. That way it makes that conversation for the surviving spouse a lot easier, rather than just saying, I want a prenup. It's my spouse and I had agreed to this. If I don't get a prenup, then I don't get to stay on as a beneficiary. There's lots of different tactics that you can do to make sure that if you are married and a spouse passes first, that you're protecting the family, you're protecting the surviving spouse from a predator, right? Or something that just happens to go bad, but also making sure that the children that you guys had together will not be cut out. The next person I'd like to introduce you to is Jake, your son-in-law, or as you like to call him, Jake the Snake. So let me tell you a little bit about Jake. You are pretty sure his religion is actually a cult. You also are pretty sure he's fond of chemical substances. And the real kicker about Jake is that he can't wait until you're dead so he can get his hands on his inheritance that he thinks he deserves rather than your daughter. So Jake the Snakes are really the reality of today's world. With divorce rate being about a 50% chance, it's one of those things that it's better to just do planning for, to make sure whatever you intend to leave for your children, go to your children instead of a divorce. So even if you have the best son-in-law though, or daughter-in-law, right? There is a chance that your child passes away first. And then by law or by their will, maybe it goes to their spouse. And then you have to worry about the grandchildren being left out because their surviving spouse will get remarried. That's just how it goes. So, really to make sure that you're protecting from Jake the Snake or a child passing away and then everything going to spouse and they get remarried, nothing going to the grandchildren, you could think about adding inheritance protection trusts to your plan. It's kind of the old way of doing estate planning, was to simply say, hey, as long as my kids are, over the age of 25 or maybe half at 25, the rest at 30, then they get it. Everything gets titled into their name and it's their asset. So it can become marital property, or if they're in a car accident and get sued. Because that's the other thing is you can have a wonderful child, but bad things happen to good people in this world. So you got to do asset protection planning. So that's the new way. Instead of just pouring it out right into a child's name, as long as they're of a certain age, now look at maybe pouring it into what we call an inheritance protection trust. Your child, even though she might be married to Jake the Snake, is making good decisions. So let her have full control and authority. It's just that it's going to get titled in a trust. She can be the beneficiary. She can be the trustee. She can manage it. If you want to put, handcuffs on from the grave and govern from 6 feet under, you can do that. Or if you trust your kids and they just, married someone that you don't trust, you can give them that freedom and that flexibility to do what they want with it. So those inheritance protection trusts are really the way to incorporate asset protection planning with your estate planning, just because, more money is lost in today's world, really on the divorce front than to the IRS. So, be smart about how you leave assets. Next up is your other son, Travis. Now, Travis likes to fancy himself as an entrepreneur and a businessman. So in the last 6 months, Travis has been involved with 5 business, opportunities and 3 real estate deals that had to do it. He unfortunately has had to ask you out of help for each and every one of them because none of them made it like he thought would happen. So sometimes when we do estate planning, we have to do asset protection planning to protect our children from themselves. So Travis is a great example of that. You can use an inheritance protection trust, but instead of giving them full flexibility and control, you have to limit it a little bit, right? So that maybe they're just getting income or a percentage, or maybe they have to meet certain incentives in order to qualify. So those are things that you can put in to protect your children from themselves. Likewise, if you've got young children, you really don't want them to receive assets at a young age. So typically, if they receive assets, so if they have no parents that are alive and they're supposed to inherit assets, a lot of times what happens if they're under the age of 18, they're going to have to go through a guardianship and conservatorship process in court. And then that court will basically say, per law, here's how that needs to be managed. There's going to be annual requirements for reporting at the court. And then once they attain the age of majority, which most states are 18, then they get it. Well, if they've lost parents and they're young, then they're probably going to not make the best decisions. So it's really important, if you have young children, protect them from themselves as well, because they need it. So then you would be looking at what typically is done through a will. It's called a contingent trust. It can be embedded under your will. It doesn't have to be a standalone trust entity. But then, if it gets triggered, it's contingent, right? If you die while they're under a certain age, then it springs up to make sure that, it's going to be managed for their health, education, maintenance, and support, and what other provisions that you put in there. Mention incentive provisions. Incentive provisions are very important because then you're saying, hey, I don't want my child to not be a productive member of society, or if they're suffering from a substance abuse issue, I don't want this trust to enable that, so you can build in those provisions. But if you've got children, there's no greater reason to do estate planning. Estate planning is not about money and assets. It's about taking care of the people you love. So make sure that you can, you're doing that, because things can happen and you want to make sure your babies are taken care of. And then on to Mike and Carol. So unfortunately, Carol had lost her husband a couple years ago, but Carol is just a lovely lady, and she soon met a man named Brady, and they had a hunch and soon became the Brady Bunch. Now, she had children from a prior marriage, and so did he. Now, everything was just going lovely, and they were having a great time. And then one day, Mike didn't return home. He was killed in a car accident. Now, that's when Mike's children got really worried. What was going to happen? Was everything just going to go to Carol? Were they going to receive anything? And then Carol's children also started getting a little bristly because they wanted to make sure their mom was taken care of. And Carol was devastated. She just lost her husband, and she was worried about her future. This strain happens all the time on families. We have, most of our families are blended families anymore that we work with. And there is such a need to make sure that you're taking care of your children and taking care of the new spouse and making sure their children are protected. You have more on the line when you are talking about blended families. So you can do this through good estate planning. You can make sure, Carol's taken care of, but your children are also going to be insured, that they're receiving something at the end of the day, especially if Carol does get remarried, right? You want to make sure that what you've worked hard for too also benefits your children. One of the things, because retirement is so big, you can do separate retirement account or separate retirement trusts. Under that trust, you can say Carol is going to get the income for life, but Carol can't pull out all of my retirement accounts. And then at the end of the day, you can pass that on to your children and then pass on to charity or however you want. But Carol's going to be protected because she's going to get the income. You also know your children are going to be protected because after Carol passes, then it's going to new children. And you can build in provisions too. Maybe if Carol gets remarried, maybe it's going to divide up more or trigger sooner. There's lots of different things that you can do. But if you don't do planning before you die, right, then there's, limited options. And then what families experience is basically being held hostage to the family dynamics. And that is not a healthy situation because everyone's worried. Everyone's on pins and needles because they don't know what's going to happen. All right, next up is the Constanzas. So poor long-suffering George, he became unemployed. So he moved back in with mom and dad, Frank and Estelle. They took really good care of him and he was living life high. Estelle was doing his laundry, doing the cooking, all was great. Unfortunately, after a year or two, what happened was Estelle started becoming forgetful. And she even kept the stove running and almost caused the house to burn down. And Frank, he fell and broke his hip. So what turned out to be, gravy ended up being George really working around the clock to make sure his parents were taken care of. And he was incredibly concerned because he had heard how much nursing homes can cost. And he wasn't sure what's going to do because his home that he had been contributing to was now their home. And obviously, he wants to make sure that they're taken care of versus just going broke in a nursing home. Now, we talked about asset protection planning with divorce. 2 tips on divorce too. Make sure you're choosing your partner wisely. Number 2, keep date night. You're talking about asset protection planning, keep date night, okay? Now, when you're talking about long-term care planning, that's the other greatest risk. That one is a 70% chance risk of needing long-term care before you pass away. And that's some sort of long-term care for those 65 or older, 70% chance, 70% chance. So don't bury your head on this one in the sand. We want to make sure that you're looking at it. So basically we have to shift the mindset when it comes to our finances, right? Because a lot of times people will think I'm going to work, I'm going to retire, and I'm going to die. Well, for 70% chance, that's not the case. For most people, you're going to work, you're going to retire, you're going to need long-term care, and then you're going to die. So just make sure that you're planning appropriately. But some tools to know about on estate planning and asset protection planning, right? One of our greater tools that we have is the Medicaid Asset Protection Trust. Now, Medicaid Asset Protection Trusts are recognized in all 50 states. Minnesota was our last holdout. There was a appeals court decision last year that got them in gear that basically said, no, you got to follow federal law. So these trusts are recognized in all 50 states. The best way to do these trusts are being proactive. Most places, California is a little bit different. They have a 5-year look back period. So that means if you'd ever need to apply for Medicaid, then whatever that office is in South Dakota, it's Department of Social Services, they're going to look back 5 years and say, did you do any gifting? Well, if you moved assets from into a trust, like a Medicaid Asset Protection Trust, that's considered gifting. So you really want to get out 5 years in advance. Now, in order to do good proactive planning, first start with just knowing, what your options are. I think always being educated on what long-term care insurance options are. A lot of people aren't doing much on the long-term care insurance side, as we're seeing more and more on the life insurance side with a long-term care rider. That way, you're going to get something at the end of the day. And the thing that you have to be very cognizant of is how long will that policy last? Because most policies aren't that Cadillac policy that pay for everything and last forever. Those companies aren't in existence. They went broke. So instead, they're going to have cutoffs most of the time that you'll see that you need to know what your cutoff is. So if they have a financial cutoff, so maybe after 300,000, it cuts off. Or maybe it's a duration. After 2 years, it cuts off. So you just have to make sure you know what limitations you are. The great thing about insurance is that it gives you cash flow. Now, as an attorney, we can do asset protection planning, but that doesn't give you cash flow to get long-term care at home, and that's where everyone wants to be. So you usually want to complement, either self-insured, make sure that you're setting it aside so that you've got that, looking at different insurance options, and then especially if you do have certain diseases that run in the family, like Alzheimer's or Parkinson's that are longer lasting, that can be financially catastrophic, right? Those are really good fits for asset protection planning to make sure that at the end of the day, you've got some life savings that you wanted to put in that trust and to protect, to make sure that you're taken care of. when you've got money, you've got options in this world. That doesn't mean you have to use it. Again, it just preserves that you have options, and you've got options when you've protected some of your life savings. And there's many other tools that we use for estate planning, elder law planning, and asset protection planning when it comes to long-term care planning. For planning purposes, just kind of knowing some statistics to emphasize how important this is that really retirement funds need to last more than 2 decades. You know, a lot of 61-year-olds are now living another 23 years. And also because we're living longer, we've got that greater chance for having diseases or chronic illnesses where we do need help. So asset protection is very important because that's where you see that financial catastrophic events, especially if you're looking at nursing home costs. So plan ahead. It's going to make sure that you're taken care of and that your family's taken care of. And some of those kind of what we would consider, you know, baseline things to make sure you have is powers of attorney. Everyone, if you're 18 or older, should have powers of attorney. So once you're 18, your parents can't make decisions for you legally, right? And even if you're married, if they're not on a legal asset together, you know, for instance, just something as simple as a cell phone bill. My husband's name's on the cell phone bill. I'm calling with a question. They won't talk to me, you know, but then I tell them, hey, I'm a power of attorney. I can have this, you know, I email that to him, all taken care of. So even for spouses, it's important, but you should have a healthcare power of attorney and a durable financial power of attorney. Within those, you should be picking your options. There is nothing more important than keeping control of how you want your health determined and making sure the right people are managing your finances for you, paying bills if you can't. A lot of exploitation comes when you're talking about powers of attorney. So never put someone down that you don't implicitly trust. If you got a little bit of reservation, don't put them down. You got to make sure that you're putting people that you trust. But powers of attorney are your lifetime documents. They're going to take care of you during your life. Now, at time of death, they become null and void. That's when the will steps in. The will is a death document. The will is your ticket to probate. So most states have a threshold of a certain amount of real estate, you get thrown into probate if you die having that in your name, or if there's a certain amount of property in your name. So for instance, in South Dakota, if you own real estate worth $50,000 or more, you're going through probate. Or if you have personal property of $100,000 or more, stuck in your name at time of death, you're going through probate. The will's the ticket to probate. That's what gets filed at the courthouse. That's what gets probated. So the will is death instructions. That's giving your family a roadmap. Here's who needs to get appointed. Here's how I want assets distributed. So basically you're kind of saving that work for them to do at the end, but you're at least giving that roadmap. Now, it's a good thing to try and avoid probate if you can, I think, because it makes it easier for the surviving spouse or children or family members or loved ones. And with that, you know, make sure that you've got beneficiary designations that are correct, because if you have beneficiary designations for spouses, joint ownership, it'll pass by operation of law to that surviving joint owner. But a lot of times people forget to look at beneficiary designations. You know, that poor fourth child seems to always get left off life insurance policies. The first 3 are on there as beneficiaries, but when the 4th one came, I guess parents were too tired, they forgot to add that, you know? So make sure that you're constantly updating and checking on those things, because those will help make it easier for loved ones. And then a lot of families do look at trusts as options. Trusts are great vehicles because if a trust owns your assets, think of that as your family holding company. A trust doesn't die and a trust doesn't become incapacitated. So trust can go on. So that's why the trust avoids probate. And typically with the revocable living trust, you know, you're in charge, you're the trustee, you're the beneficiary, and then you give the death instructions too, what happens at time of death, but you don't have to go to court. And you really, you know, depends on how you're structuring it, but can make it so much easier for the family as well. So being educated about different trust options, and there's a whole alphabet soup of trusts out there. You know, we have everything from DAPS, the Domestic Asset Protection Trust, to the Revocable Living Trust, and everything in between. So it's one of those things where you want to be educated and make good decisions for your family. You don't want to leave money on the table. You want to make sure your loved ones are taken care of. And some of that just starts with being educated. All right, so now we've got JR and Bobbi. So JR and Bobbi, even since the time they were just little kids, they have never gotten along. JR has kind of been in love with the almighty dollar, and Bobbi, on their hand, is just the complete opposite. And they really, it's kind of like oil and water. They don't mix well. Now, for Bobbi and JR, I'm just going to jump to the end of the story. After parents pass away, in this situation, when you got two kids who've never gotten along, the only one that's going to win in that situation are the lawyers. So if you've got that situation, do good planning from the beginning. So a lot of times when you've got children who you know aren't going to get along, first, don't ignore that. And then second, plan for it. So you can build in things like no contest clause so that if someone tries to contest something, they stand to be disinherited. You can build in exoneration clauses. You know, it's pretty sad what we see when, you know, maybe one child was helping parents while they aged and before they passed, and another child wasn't even knowing what was going on. And all of a sudden they're starting to sue that child who was helping them. You know, if that's the situation, you can insulate them so that it has to be a good faith claim, and put requirements on there to protect your children who are helping you. And just to, you know, try to ward off that fighting amongst each other. You can build in mediation, arbitration clauses. There's a lot of things that you can do. One of the most basic things that you can do though is communication. So mom and dad are always going to be the glue. And when that glue comes off, right, and starts weakening, a lot of times you see that while people are still even alive, you know, it's so important to set the family up prior to that so that you've had communication. You know, communication is critical. And where the soft spots are in families, right, you know, where those tension points are. First, as on healthcare. So having discussions about healthcare decisions at a table side prior to a bedside is very important for family harmony. The other one is at the funeral parlor. Lots of families fight in funeral homes. So having decisions made ahead of time. And that's hard. You know, a lot of times we'll meet with clients, they're like, I don't know if I want to be cremated or buried. And, you know, we always say, well, you think about it, but if you don't know, you know, what do the children think then? They're really going to be lost usually. And that's not the thing we want them stewing on at the time. We want them to be able to celebrate your life and to hopefully surround each other versus getting into fights about that. What I do tell folks is that just keep in mind, cremation is an irrevocable choice. At least if you go with burial, you can always exhume the body and get cremated later. But the point is, you know, let your loved ones know, because we know that is a tension point for families. And then the last tension point is really that estate administration. So having clear directions. Again, I meet with people all the time that say, my kids don't really care. I've just got a bunch of, you know, stuff. They don't care about that. That is not true. You know, if you do have stuff, right, you can do a personal property memorandum and say, here's who I'd like things to go to. And you can keep that updated. And that's going to be legally binding as long as you're following those state laws for that. But, you know, honestly, we've here, just even in my office, we've had fights over dad's high school diploma, who gets that, a wooden post hole digger, Christmas ornaments. I mean, the list can go on, because a lot of times maybe they don't act like they care, but then when mom or dad's gone, they do. So if there's things that you know could be a sensitive issue, it's so much better for you to decide. Now, if you've got younger children, it's also important for you to do this planning, because if something happens to both you and your spouse, for instance, and there's no parent alive to take care of children, you can't keep everything. And so for parents to make sure that they are hanging on to certain things, and the greatest things in life aren't necessarily, you know, the monetary things. So make sure you let people know maybe a certain book is really important for you to pass down to a child, and then write why. Capture the story, capture the meaning of why you want them to have that with that. Because especially if you got younger children, they're not going to be able to keep all your stuff, right? They're going to have to go through, throw, donate, give away, whatever it might be. They can't keep everything. So at least make sure that you're selecting those things that mean something that you want them to have with mom or dad. All right, next one is Rick, your business partner. For those that you are business owners out there, or as you are now calling him, Slip Rick, because he's pulled some fast ones on you. So if you do have any partnership interests in anything, you know, sometimes we'll see people will have real estate with others or with other family members even, right? or maybe they have a business where they've got a business partner. Make sure you've got the legal documents in place that if one of you becomes disabled, if one of you dies, there's a clear roadmap for what that buy-sell will look like, or how the family of that partner will be taken care of, what happens, that discussion. But then most importantly, getting it legal, right, in writing, because memories fade and other family members might not know, and protect from each other, because sometimes there really are slick Ricks that we're in business with and we don't find out until later. So protect yourself and protect each other, right? You might have a wonderful partnership. So honor that and make sure that it's in writing, because if one of you all of a sudden gets hit by a bus, your families probably don't know. And last but not least, the infamous Kardashians. So they really don't need much explanation. But the thing that we can all learn from them is sometimes the things that are, high value are ourselves and what we're posting on social media, what we're becoming, right, has value on the intellectual property side. So if any of you are doing that, I want you to think of that as an asset. You got to do estate planning for it, but more importantly, you got to do asset protection planning for it so that you're preserving your value during lifetime. That's the same thing as that we see so many, especially of our clients, that they're working hard, but they also got a side hustle going on, right? They got another thing that they're doing, and make sure that you're protecting that. You do have a lot of time, right, and investment wrapped up into that. Make sure that if you have another business entity, for instance, or a side hustle, think about using LLCs to protect that. Or maybe you got a couple rental homes or a rental home. If something goes wrong with that rental home, you don't want it to be able to get to your nest egg, right? You want to make sure business and personal stuff are separated. So doing good planning is very important. And then kind of going back to that intellectual property or digital assets. For estate planning purposes, make sure that you are planning in case you get hit by a bus, because a lot of times what we can do on the legal side is make sure you have legal authority, right? That legally you're protected. But then there's the other side, that's the practical side, knowing usernames and passwords. For our clients that struggle, make sure that there's some way that you can pass those passwords down, because a lot of fraud can happen after a person passes away. So for family to make sure that they can monitor things is very important. And also with incapacity too, to make sure that you're monitoring that is very important, and having the right people to help. Sometimes for clients, it's very useful if they can have a digital password bank. Pick, 10 highly secure passwords that you can, essentially recycle, but that way the family knows that they will eventually hit the right password to be able to manage. All right, so on to the death portion, right? So my specialty is basically kind of the dead, dying, and incapacitated is what I joke. But really, we want to think about living a legacy, not just leaving a legacy. I think both are very important, but it is very humbling for what I do to be acutely aware that any day could be our last and we have no idea. So living a legacy is very important. Don't wait to start living the life that you are proud of, or to make a difference, or whatever it might be. It's not necessarily the big things, it's the little things that matter the most. So make sure you're living a legacy. And that is the same way too with what we're doing. Sometimes the smallest amount that we are now no longer spending on that Starbucks coffee, but maybe giving to as an alumni, right, back to this school. And that's the same way with leaving a legacy. Make sure you're setting up your loved ones so that they stay loved ones and that they continue talking after you're gone. And if there's things that are near and dear, to your heart, this is a great way to give back. And I know as fellow alumni as well, one thing that has definitely, changed me is where I went to college. And as that person, I look at my diploma hanging in my office as an investment that is still an investment. So if the school still has, a good reputation, my investment in that diploma continues to grow because we really are reflected as a group, and it is a privilege and honor to be part of that group. It's also going to help others too if we pay it forward. So we can help fellow future students at the school, right? Make sure that they're getting opportunities, and who knows how that can come back and pay it forward to others as well. And then me personally, I just think of how it's changed my life, the opportunities that I went just from picking the college that I went to, the friendships, the experiences that I had. So I do look at, when you're looking at legacy planning, think about the things that have changed your life and how to give back. And I know personally, one of those things was my school. So anyway, so maybe while you're doing some thinking about legacy planning, think about some of that stuff and then be intentional. But I'm going to leave you with another animal picture. Don't procrastinate. The number one reason why people haven't done estate planning. So first, only about 33% have done estate planning. That's according to caring.com, their survey. And then the other reason, the biggest reason, the number one reason people haven't done estate planning is that they simply haven't gotten around to doing it. They have all the intention in the world to do it, but just haven't gotten it done. So don't be a stubborn donkey and make sure that you get it done, because, you know, I think kind of like you got to be responsible for things that matter to you, right? Taking care of your loved ones is one of the best and biggest responsibilities we have. But don't procrastinate, because we don't know when that bus is coming for us. So what's next? So protect what you already have. All of us, I can guarantee it, on this webinar, work our tails off, right? So protect what you have. And all of us on this webinar have loved ones that we care about. Protect them. So the next one is create a plan for where you want to go. And then number 3, expertise and experience matters. So oftentimes people will ask me questions about divorce, or I don't know, I have no idea about the other stuff, right? So much like you wouldn't go to a computer engineer to ask them to, design that bridge, make sure that you're seeking an attorney who has that expertise and that experience, because you're planning for your loved ones, right? And you're planning what you've worked all your life for. So it's very important to do it right. So plan. And despite medical advances, there is still a 100% mortality rate. So make sure you're getting it done. And thank you. So Leah, I'll turn it back over to you.
Hi, Bobbi. I thank you so very much. This has been amazing and intense and dense with information. So I just want to remind everyone out there that we are going to upload this onto YouTube. The other thing, we do have several questions. I don't know if we'll be able to get to all of them, but we'll get to a few of them. And then I was going to see if maybe you could answer a few that we can do a follow-up email with the link to today's message on YouTube, the answers to these questions that we don't get to, and then your information, so that we can continue to share that, and then some of Leah's information too. But Leah, do you have one of the questions that you definitely want her to answer live?
Here's one that perhaps you could answer for us, Bobbi. Regarding charitable giving, can you address the difference between using a trust versus designating charities as primary or secondary beneficiaries?
Yeah, I'm going to give you a lawyer answer on that one, and it just depends. So it really truly depends on, what you're looking at for asset. Are you looking to get income from it? Are you looking to maybe let your children have income from it and then go to a charity? It also looks at the assets that you're having, because sometimes those trusts are used more for than retirement accounts. So if you do have stock that's appreciated in value, or real estate that's appreciated in value, and maybe you're going to sell that, then putting that into a trust, you can actually get, a double bang for your buck, because you can get that charitable, contribution that's made, but then also income tax deduction too. So if you've got different things going on, I think it's always prudent to just know how you can keep more in your pocket and benefit those that you love.
Thank you.
But the beneficiary designation is nice. And if you're trying to keep it simple and easy, right? and it is straightforward, you can just do a beneficiary designation. And it's nice because you can update that as needed. Just make sure you do have a beneficiary designation down, because most people seem to forget that, especially the contingent beneficiary.
Thank you, Bobby. Here's another one that's relevant. This person wrote in, a retired couple I know was told by their planner that they don't have enough money for a trust. Is there a minimum? They're not rich, but they have 2 homes and a rental, and they live comfortably.
Yeah, so there's not really necessarily a monetary amount. So sometimes I'll meet with a client who really just has a retirement account. That's where all the money is. And, you know, if that's where all the money is, you don't ever want to put a retirement account in a trust where you lose tax deferment. So for them, a trust would not be a good idea, even though they might have a $2 million in retirement accounts, right? So it's not necessarily the monetary value, it's the return on investment that you're getting from it. So if you have property, so here in South Dakota on the east side, I'm right by Minnesota, right? And so some of our clients have property in Minnesota and South Dakota. And so for them, if they get hit by a bus and they've got a lake home in Minnesota and their primary home in South Dakota, their family is going through 2 probates. So if you put the home and the lake home in a trust and coordinate the other assets, you've just eliminated 2 probates for that family. It's, you know, it's going to save you thousands of dollars, and then also make it so much easier on the family. So it really is going to depend on your individual situation.
Okay, thank you. Here's another question that's relevant to all of us, I think. As a general rule of thumb, how often should we get our plan reviewed when there have not been significant family or life changes?
Yeah, that's a great question. So I'll just speak to what we do at our firm. We do 3-year complimentary reviews with our clients. So we think 3 years is a good amount of time where even though you think nothing's changed, something might have changed. It's worth blowing off the dust and make sure that everything's still good. And then also because sometimes you might not think things have changed, but legally something has changed. So that way you're touching base and getting an update kind of on the laws and how you can maximize your planning.
Okay. Here's another one regarding the inheritance of IRAs. How does the Secure Act treat special needs grandchildren?
Yes. So with the, I think with the retirement planning that we have with the Secure Act, it gives a wonderful opportunity to do special needs planning for family members who do have special needs. Because if you complement that with a supplemental needs trust, that grandchild can continue to get tax deferment the rest of their life. And then you can also pass it down to whoever you want to after that. Then you're making sure that the government doesn't get reimbursed. They don't lose eligibility for government benefits that they might need for healthcare and other things. So I think it's a great opportunity to look at with retirement, because if you're leaving it otherwise to a child, for instance, they're going to have such a big piece of the pie going back in taxes that you're not maximizing keeping it in the family. So special needs planning is you got a little bit more complication there because you've got government benefits that you've got to do planning for. But at the end of the day, I think it's very worthwhile looking into.
Thank you both, Leah and Bobby. I appreciate that. We didn't get to every one of our questions, but we got to a lot of them. I want to remind everybody that we will upload this video to YouTube. We will send out an email to everyone that was here today with the follow-up questions that we didn't get to, links for Leah on some next steps that you can ask from her, information for Bobby, so that in case you want to get back to her. Again, I put a survey in the chat box. So if you guys wanted to fill that out, that just helps us to make the nudge and learns with the information you want to have. I didn't do a great job of introducing myself earlier. My name is Shelly Gernager. I'm the new Director of Alumni Relations here at South Dakota Mines. And again, I want to thank Bobby for your time and your information and your passion that you got to share with us today. And I hope to see all of you at some of our future department updates and lunch and learns. I put those also in that chat function, and we will also include that in our follow-up email to everyone. So again, thank you all, and I hope you have a great day.